conditional use hearing for the concerning the application of Mountain Trail Solar LLC for the Windsor Township Board of Supervisors. And before we proceed with testimony tonight, there was a renewed objection that was lodged by the applicant. Is everyone able to hear me okay? I said okay. There was a renewed objection that was lodged by the applicant with regard to an entry of appearance that was filed by Jessica D. Lang on 241 Hefner Road, which has been previously marked as Board Exhibit number 18. I received an email this evening at 5:32 p.m. From Ms. Lang indicating that she would not be attending the meeting this evening. And we will be proceeding with an argument on that. And then at this point, I would ask Mr. Gallagher if he has an argument on this issue.
Right now, I do. As outlined in what's been identified as Exhibit 40, is the renewed objection to the standing. Thank you. To the standing and party status of Ms. Lang. Attached to Exhibit 40 are three exhibits, Exhibits A, B, and C. A is Ms. Lang's entry of appearance, which she filled out and lists her address as 241 Hefner Road. Exhibit B is a map showing the distance from the site to 241 Hefner Road, which is 1.7 miles. And Exhibit C is Berks County property record report showing that 241 Hefner Road is not owned by Ms. Lang. So as outlined, there were, well, to take a step back, there were a number of parties who entered their appearance in opposition, which we did not object to because they live in sufficient proximity to the site. Under well-established case law, you have to be in close proximity. One, you have to be a property owner, and two, you have to live in close proximity. And all of the cases that we have cited to, 1.7 miles, even if she owned the property, is well outside of that circumference for standing.
Thank you, Mr. Gallagher. Mr. Clark, do you have anything on this?
No, I don't.
Do any of the other parties who have entered their appearance have wished to address the board on this issue? Let the record reflect that there is no response. Do any members of the board have any questions? The renewed objection of standing and party status of Jessica D. Lang will be sustained, and her status, she will no longer be deemed a party to this proceeding.
Thank you.
Is Mr. Hughes here?
Right.
Okay. So we're going to proceed with the testimony this evening of Mr. Hughes.
Correct. Cross-examination.
Yes, cross-examination.
Paul, do you want to stand or sit?
I'd probably prefer to sit, but I don't have access to any material that they did.
Yeah, we might have to do it.
But I will be,
I mean, there's a podium too if you want it. Sitting.
I can use the podium. That's all right.
You can.
Mr. Hughes, you remain under oath from your previous testimony. And can you confirm that you have not discussed your testimony with anyone since you last testified?
Yes, sir.
Okay. I believe we were in the middle of Mr. Clark's cross-examination, so Mr. Clark, you are free to proceed.
Good evening, Mr. Hughes. If I have the mic here, can you hear me in the audience? No. Move it closer. How's that? Any better? What is it better?
It's just this one.
Is there a volume control somewhere? Nope. Okay.
Just have to use your loud voice.
Mr. Hughes, do you have a copy of the wetland study available?
I have those in the packet.
Are you referring to exhibit number 7? the
Correct.
Wetland delineation report?
Yes, I have Exhibit 7, wetland delineation report.
He does not have, sorry to interrupt.
That's okay.
He does not have, Exhibit 7 has a copy in here that just has every other page. So he does not have the full report.
He's got the one missing page.
Yes.
I just confirmed that, yes, that's good.
Do you have copies of?
I do not with me, but you do. It's one of the exhibits. It's board exhibit.
I'm going to be going back and forth. At this point, I'm only doing page 1, so we can just go forward. Mr. Hughes, you have the cover sheet.
Yes.
This is, for the record, this is applicant's exhibit 7. The version of the wetlands report submitted with the narrative and the exhibit book was complete. And if you go to the board's exhibits, the supplement for board exhibit 1 contains the narrative and the exhibits, and that's a complete copy. Unfortunately, the applicant's original exhibit 7 only copied every other page. I don't have any objection, Paul, Sean, if at some point you want to substitute the full as exhibit 7, unless the board wants to do something different.
No, I don't see any reason why we couldn't at some point just replace those pages in the book. I believe it was an error. It was an unintentional error.
Right, and for purposes of people accessing exhibits through the share file, we at some point will substitute the complete for the one that's on there now.
That's already, I have already posted the full version of it. When I received it from Sean, it was put up immediately, so it's been there.
Thank you. Your firm, Mr. Hughes, your firm prepared this wetland delineation report,
Yes.
and it was originally prepared May 24th of 2022. And the cover sheet says this is revision number 1, November 21, 2022. Are there any other revisions for this report?
Not that I'm aware of.
And what was the difference between the original and the revised version, if you can summarize, or if you even know?
I don't know.
Okay. Turning to page 1, under introduction. It begins with Leeward Renewable Energy Development LLC proposes development of a solar energy generation facility. It then identifies certain properties. You're with me?
Yes.
The first one has a parcel number that ends in 8622 that appears to be owned by Gaspari, correct?
Yes.
And then there's three, I'll call them parcel numbers, associated with Frederick, correct?
Yes.
And then there's a fifth one that's a portion of the Sunday parcel.
Yes.
The next sentence says solar panel arrays are proposed on the former three parcels. Which three parcels are proposed to contain the solar panel arrays?
I believe that should say the former four. One disparity, three treasure.
So to state three parcels would be incorrect?
It appears so, without looking at the plan, but the intent of the statement, I believe, is to identify one parcel disparity, three parcels Frederick as panel parcels, and one parcel Sunday as easement only.
Sunday is the right-of-way easement, correct?
Yes.
Okay. Did you perform a wetland delineation for all four properties proposed to house solar panels?
Yes, I did not perform any weather delineation, but yes, a weather scientist employed by County Board.
One of your employees?
Yes.
And you've reviewed this document?
Yeah, generally.
Do you have any reason to believe there's anything else that's inaccurate within this document?
I have no reason to believe that except for every other page missing.
Is it your testimony that all four parcels will contain or propose to contain solar panels?
Again, without looking at the plan, that's my understanding, unless there's a piece of Frederick that doesn't physically have a parcel on it, I have to take a second look at the plan.
Did an original version not include solar panels on two of the lots?
Well, the original version didn't include the Frederick piece, the Frederick tract at all. If that's what you're getting at.
I'm just trying to understand the narrative. Objectors exhibit number 1 talks about 5 properties. And when I saw the wetland report and it talked about 3, now I'm concerned and confused about where are the panels and where are the wetlands, and was all of the proposed 400 some acres properly delineated for wetlands?
Yes, and it was also confirmed in the presence of someone from U.S. Army Corps of Engineers.
In presence? What do you mean?
Yeah, our wetland guy, as I call him, walked to review the placement of the flags, the delineation markers, with someone from the U.S. Army Corps. That was the premise for the jurisdictional determination.
Turning your attention to applicant's exhibit 23. This has been identified as a preliminary jurisdictional determination from the U.S. Army Corps of Engineers. It's dated March 20 of 2023. Is this the only correspondence from the Army Corps of Engineers with respect to proposed wetlands on the site?
I believe so. It's the only correspondence that I'm aware of. If there was other correspondence, such as email traffic and the like between our level scientists and some members of the Corps or member of the Corps, that makes it, I don't know. I'm only aware of this called formal correspondence.
This exhibit is a two-page letter, is that correct?
Yes.
Okay, looking at the second paragraph, it begins the findings of this PJD. For the record, PJD is a preliminary jurisdictional determination. It says the findings of this PJD are documented in the enclosed PJD form. Where is the enclosed PJD form?
I do not see it here.
For clarity of the record, please, are you referring to Exhibit 23?
Yes.
Thank you.
The locations of aquatic, I'm reading from the letter. The locations of aquatic resources are depicted on the enclosed plans identified as Figure 6 Wetland and Water Delineation Plan dated June 20, 2022, sheet 101, prepared by Kimley Horn. Where is the June 20, 2022 document?
It's not attached to the letter.
Why were these two enclosures referenced in the letter not included in this exhibit?
I can't answer that.
Have you seen those enclosures?
Yeah, they exist, and they're the premise for the delineated areas shown on the site plan.
Third paragraph. The PJD is non-binding and indicates that there may, the word may is underlined, be jurisdictional aquatic resources on the subject site. PJDs are advisory in nature and may not be appealed, and then there's a parenthetical. See enclosed notification form, parenthetical closed. Is that a separate document, or is that the PJD form that was referenced in paragraph 2?
It appears to be referencing the same form. But I don't know if the notification form is separate from the PJD form. They're not included here.
Turning to the second page of Exhibit 23. Do you see where it says enclosures?
Yes,
None of those enclosures are part of this exhibit?
that's correct.
Paul, could you give him page 2? I'm sorry, Sean, I'm going to keep going. Somebody have page 2 that you have to the witness? Do you see page 2?
Yes.
At the very top, the carryover from the prior page says, aquatic resources immediately outside the site were noted and mapped approximately but not delineated. What does that mean?
I think that means, again, this is not my direct field, what I think that means is they were mapped approximately based on existing features, but not formally flagged with flags in the field and plotted with the mentioned GPS receiver.
Under results and discussion, section 3.1 desktop, in the 5th paragraph that begins topographic mapping. Do you see that?
Yes.
It says topographic mapping reveals the site contains several hills and valleys, comma, with steep slopes in places and elevation changes of up to approximately 200 feet. What was determined to be a steep slope? What percentage was relied upon for this project?
I don't know in this report what those words mean if they reference the slopes as mapped, or I'm sorry, as tabulated immediately there below, or if it references the ordinance. It probably does not reference the ordinance, to be honest. I don't see where it defines exactly what steep slopes are, aside from, if you look through this table with the soil survey, there are soils listed as 3 to 8, 8 to 15, 15 to 25, 25 to 60, with how many acres on the overall site. But again, I don't know from the information on the page at what threshold Max, my guy, is referring to steep slopes.
So you don't know if the Berks Weikert, W-E-I-K-E-R-T complex, which has the map symbol of capital B, lowercase k, capital C, which says 8 to 15% slopes, of which there are 331.7 acres on the site. You don't know if that was considered a steep slope for purposes of...
I don't. It doesn't say what the threshold is. We know what the ordinance says. It's going to start at 15, but this, unless it's somewhere else in the document as far as a definition, I'm not aware of that being defined.
The sentence I read previously says topographic mapping. Do you have the topographic maps that were used for the wetland study?
I have them in my files and systems, and I have them on my personal.
Were you asked at the prior hearing to produce the topographic maps that were prepared for purposes of the application?
I was asked where they were.
Let the record reflect there was a request for those topographic maps to be produced. I can look up the transcript if necessary, but I have notes that indicate I'm supposed to be seeing topographic mapping. And my question was going to be whether the topographic mapping produced for purposes of the application is the same topographic mapping used for the wetland study.
There's only one version, so it is.
Mr. Hughes, you said that you have those maps on your person? Or you
No, I said not having one on my person.
Okay. The objection is noted for the record.
Well, I guess I'll reserve my right to continue this subject matter at the next hearing, and I assume the witness will bring the topographic maps with him. Is that a fair assumption?
I don't-
Mr. Gallagher, what's your position?
I don't have one right now. I mean, we revisit it after we get done. I don't know that it's imperative to his testimony, but.
Mr. Clark, are you able to proceed with the balance of the process?
Oh, absolutely. Oh, yeah, no, I'm just meant for this portion. Oh, I have plenty to
I think that we will see where we are at the end of the evening.
Mr. Hughes, do you have the narrative available?
The general application there,
The narrative that was attached to the formal application that was not included in the notebook, the applicant's notebook. That is included. Yeah.
You have, I believe that's Board Exhibit 1, that does have the book that I handed you does have the narrative.
Okay.
Keep that handy. Most of my cross-examination will be reviewing the narrative. Starting with paragraph.
The whole book is. The narrative starts at the beginning of the book. Oh, it's up front. Yeah.
Narrative, the first 15 pages, respectfully submitted by Mr. Gallagher on behalf of the applicant, Mountain Trail Solar.
I have 14, but I believe.
Paragraph 5 on page 2. The subject property
Another copy. Sorry. Yeah, copy.
of the narrative?
Yes.
No. The subject property consists of approximately 476 acres of open fields and wooded land. Where did that number come from? I thought this was 449 acres.
Bear with me, I'm looking for the plan tabulation.
Mr. Solicitor, you have the 18 conditional use plans there, the large, the oversized ones? Why don't we get them set up, because I'll be going back and forth with them. Look at what you need to look at to answer the question.
Yeah, so I see,
Just for the record, can you please identify what you're referencing?
I'm referencing the cover sheet of the conditional use plans, sheet C-000.
I believe that is Exhibit 1, Board Exhibit 1, a portion thereof.
I think they call it supplement, but it's Board Exhibit 1.
And so I'm looking at the project description and the narrative, or the total acreage listed as 449.55.
I see that. So where's the 476 in the narrative come from?
I don't know, I can just tell you that it says 449.55 on the plan.
So paragraph 5 in the narrative contains inaccurate information regarding the number of acres.
That appears to be the case.
Under subject properties, do you see that? On the, no, the same doc, on the CU plan C-000. Who's the current property owner for map number 1?
Gaspari Mushroom Company, Inc.
Does it say mushroom?
It says mushroom.
M-U-C-H-R-O-O-M Company. Is this the first version of this document?
No, it appears there are a couple revisions.
That mistake wasn't caught in the revisions?
Apparently not.
Hold on. Who is the current property owner for map numbers 2, 3, and 4?
Dale D. Frederick.
Is that the correct spelling of Frederick?
It appears there should be an E between the D and the R.
And that error also wasn't caught in the revisions to the plans?
It appears so.
And who is actually the owner of those 3 lots? If you know.
If it's not Dale D. Frederick, as it's listed here in the narrative and on the plans, then I do not know. If I may, there's an owner listed in the memorandum of option contract, listed as Dale D. Frederick and Catherine A. Frederick. Collectively.
So
I'm
those,
sorry, in Exhibit 2.
so that's the actual owners is the husband and wife, not just Dale.
I don't know, I'm just reading what's on the page.
Okay, so once again, paragraph 4 of the application and the conditional use plans inaccurately identify the current property owner of the parcel proposed for development of the solar farm, correct?
Well, I'm reading from the option contract, not from the deed or order of deed, so so it appears to be the case, I just can't confirm that myself.
Well, did your firm prepare the conditional use plans?
Yes.
And what did you rely upon for the information in the plans?
Typically, the ownership as delineated on the survey, but I can't express exactly why the full ownership name of, as it's stated here, husband and wife isn't listed on the cover sheet chart as it is.
Looking at C-000, that's the first page of the conditional use plans. There's appears to be an aerial photograph of what's defined as the site. Do you see that?
Yes.
And can you identify the parcel numbers? Do they match up with the map numbers on the left side of this exhibit?
Yes.
Okay, so for example, where the number 1 is, that's the Gaspari Mushroom Company.
That's correct.
2 is Frederick, 3 and 4 are Frederick, and 5 is the Sunday property, correct?
Yes.
Now turn to the second page, C-001. And I think I asked this previously, why is it X01 or X02 when the sheets that follow are differently numbered?
Yeah, that's a good question. So that's an index map, and in this set, and as you can imagine, as the set grows with more engineering and sheets, the X indicates that all the different types of plan sheets either start with a 1, 2, 3, 4, 5, and so on. The index, as far as how the sheets are cut, as we say, stays the same in terms of the orientation on the overall tract or overall site or project area. So it's just a way to indicate that everything that's X07, or whether it's 207 or 407, is going to depict the same area.
And looking at the second page of the exhibit C-001, on the top right it says sheet list table, and those are accurate and they reflect the next 15 or so pages. Okay, the top right hand sheet list table, right?
Yeah.
Okay. And then there's a legend underneath.
Yes.
And the first legend item in what appears to be, well, I was about to say a solid red line, but you tell me for proposed project area, is it solid or is there an X and a dash in there?
There are a pair of dashes, I would say, periodically throughout the solid red.
Okay. And looking at the engineering drawing, where's lot 3 and where's lot 4?
So the lots are, and it's maybe easier to see referring back to sheet 000, they're essentially internal to the overall, I'll call it the Frederick tract. So on 001, the internal lot lines, if you will, are not depicted.
So if we go to C-100, the next page, the overall site plan. That also doesn't include lot lines.
That's correct.
If I go back to C-001, where it says C sheet C-X02, is that what becomes known as C-101?
Sorry.
Let me strike the
No.
question, I misspoke. It says, what looks like the Frederick parcel number 2 references 2 different sheets, C-X01, C-X02. Which site plan document is reflected by X01 and X02? Is that C-101 and C-102?
Yes.
Okay. Does C-101 or C-102 depict the lot lines?
No.
The township's engineer, Great Valley Consultants, on October 17 of 2023 submitted a review letter. Did you receive a copy of that letter?
We did. I don't know if we have it.
I'm just asking if you got it.
Yeah.
Is there a response to that letter yet?
We didn't issue a response, if I recall correctly.
You did not?
We did not issue a response.
Okay. Now, the conditional use plans were revised a couple of times, and it appears to be in response to comments from the township's engineer, Great Valley Consultants, correct?
Yes, both revisions are stated as having been revised per those letters as stated.
Why wasn't the narrative revised?
I can't answer that.
Paragraph 2 of the narrative. It says the solar facility and at its initial caps, it's considered a quote, commercial solar energy system, close quote, use under the Windsor Township zoning ordinance. Do you see that?
I do.
And there's a definition of commercial solar energy system in the zoning ordinance. Are you familiar with that?
I am generally, I can't read it to you word for word, but yes.
How many solar panels are proposed for this project?
I don't have a count of the panels in the modules.
Does anyone?
Well, the project's not designed yet, so no.
So you don't know how many panels will be sited on the 400 some acres?
The project's not designed.
So how did you determine stormwater management pre-development, post-development without knowing the number of panels?
The panels occupy a space, but it doesn't matter how many modules there are. There's nothing that's going to say design is based on 4,622 modules or anything like that. It's just an overall area, square footage, otherwise.
And what's the space between each panel?
I can check that. Do you mean in the row or between the rows?
Both.
Because between the panels, they're just essentially a button.
And what's underneath the panels?
The ground cover, meadow grass.
And what's the ground cover in the spacing between the rows of panels?
The same ground cover.
The access roads, what do they consist of?
What we would call aggregate, essentially stone.
Was that considered to be impervious for purpose of calculations of lot coverage?
Absolutely.
Has there been a determination on what type of solar panels will be used?
If you mean between the general options of fixed tilt versus single axis trackers, my understanding is that the project would be fixed tilt.
Okay. And then there's different types of individual panels. Do you know which type?
As far as make of module, I do not.
What is a light reflector?
Something that reflects light, I don't know.
Are there any light reflectors as part of the commercial solar energy system?
I don't know.
What is a concentrator?
I don't know.
What is a heat exchanger?
All things that are not my purview.
How many substations are proposed for this project?
There are 2 pads that are allocated for substation / switchyard use, as I understand it, that a bunch of electrical engineers will design.
What's the last part?
That a bunch of electrical engineers will design.
What's the proposed height for the substation?
I don't have any specifications on the substation.
I believe you said you've worked on a number of other solar projects.
Yes.
In what capacity? As an engineer?
As a civil engineer, and generally call it entitlement permitting phase project manager.
And did any of those solar projects have a substation?
They all do, I believe.
And what is the height of those substations?
I'm not privy to those design documents. They're typically done as design build by another consulting firm in all the projects that we've been involved with. And we don't have on-site inspection responsibilities, so I don't even see the substations.
Paragraph 3 of the narrative generally says section 403.4. Capital letter G of the zoning ordinances, commercial solar energy system uses are permitted as conditional use in the agricultural district. And it's your understanding that all of the lots are within the agricultural district?
That's my understanding, yes.
Is industrial use authorized in the agricultural district?
I don't believe so, but I don't have a list of permitted uses in front of me.
Paragraph 4 of the narrative, under the heading of the subject property, it says Gaspari and Frederick have entered into option contracts to lease and/or purchase the subject property, the mountain trail, for the purpose of developing the solar facility. It then says Sunday has entered into an option contract to provide right-of-way for transmission to connect the Gaspari and Frederick properties. It then references Exhibit 1. I think we established at the last hearing that Exhibit 1 is not an option contract with Mountain Trail. But what is Exhibit 1?
Well, assuming that's Exhibit 1 of the option contract, I would need to flip to that.
That's a good question. Is the version of the narrative you have has Exhibit 1 and Exhibit 2?
No.
No. So Exhibit 1, at the end of the narrative says proof of ownership, which I guess is Exhibit 2 in the packet.
Okay.
Does that make sense?
No, hold on. Let me see what I have. Yeah, after the 14th page,
Yes.
a blank 15th page says Exhibit List. Exhibit 1, proof
Yes.
of ownership. The next page says Exhibit 1 on the bottom in a yellow tab.
Oh, in that case, I do not have that. My version does not have that, I should say.
I'm handing the witness part of board exhibit number 1.
Okay, and yes, I see an option contract with a yellow Exhibit 1 sticker.
What's the document called?
Memorandum of option contract.
Do you know if a memorandum of option contract is the same thing as the actual option contract?
I sure don't.
Okay. I'm done with, can we turn that? Back to paragraph 5 of the narrative. It says, the area surrounding the majority of the subject property is largely rural and agricultural in nature. There are residential dwellings located along the northern and southwestern borders of the subject property. Are there residential dwellings anywhere else near the subject property, or just the northern and southwestern borders?
You know, upon hearing that, I'm seeing the area between Frederick and Gaspari. There are a few residences. Exactly what geographic term you use to locate those. I know that there are also, I think, a couple residences, I would say, on the east side of Gaspari.
So is it fair to say that paragraph 5 is not accurate?
I would say, I wouldn't necessarily say not accurate, I'd probably say overgeneralized.
How many residential dwellings are adversely affected by this project?
Objection. Sorry,
Mr. Clark, do you have a response?
I didn't hear what it was.
It's argumentative.
Argumentative, okay, that's okay, you didn't have a mic. The objection was argumentative. I'm just asking how many residential dwellings should have appeared on these maps?
So that's a different question, so are you rephrasing?
I'm rephrasing, I'm not going to say adversely affected, that will be determined at a later time. The question is, how many residential dwellings are depicted on the plans?
I don't know, I can just say, looking at the arrow, whatever's can be seen from space is depicted.
Paragraph 6 of the narrative. Mountain Trail is proposing to construct the solar facility on a portion of the subject property that is located in Windsor Township. ... Are all 5 lots contained in Windsor Township?
I believe so.
So when it says a portion, that is not saying all of Windsor Township. It's just saying some of Windsor Township.
I think the portion is attached to property in that sentence, not township.
I just want to confirm there's nothing outside of the jurisdiction.
I should have known. Whoever said it is.
Paragraph 7. The proposed facility consists of a collection of solar panel arrays. What is a solar panel array? A-R-R-A-Y.
So my understanding of the industry standard is you have modules, and then collections of modules create arrays. So it's just a way of saying a bunch of modules. So in the same way, if you have multiple things in a row, you would call that an array of those things, whatever they are. So it's a commonly used term for the collection of panels that comprise a project. In some cases, I've heard arrays referred to as, you might have an array in this portion of a project and another array in this portion of a project, and they may be 2 separate arrays as delineated by for construction phasing or something like that. But that's my understanding about the industry uses the term array.
Is that the same as a solar array field?
I would say, I don't know, a solar array field could be, like I just described, multiple arrays that create the field, but I don't know that I have an exact definition from solar today right now.
How many solar panel arrays are proposed for this project?
I would have to count them up again based on my definition of kind of each separate collection being a separate array. If you'd like me to do so.
If it's possible to do that within a reasonable time?
I'd say depending upon how one would define exactly what an array is, I think we've got like 8 to 10. There's a couple areas where there's just a handful of panels that are separate from other panels. Another way, and I'll just leave it at that. Let's call it 8 to 10. Kind of separate, distinct array areas. And again, project hasn't been designed. Typically designed by contractors design these, the electrical engineers do the final engineering, and the arrays that also look very, very similar, but are slightly arranged differently for final construction.
What is a designated operations/maintenance area?
Exactly what you said.
Well, is it, I'm assuming it's constructed.
If there's a designated what do you call it, operations and maintenance?
Designated operations/maintenance area.
Yeah, if there is such a thing on a project, then presumably it would be something that would be constructed as at least an aggregate pad for, maintenance vehicles to park on. I can't think of any of our projects where we've had what you would refer to more of as an operations and maintenance type facility or even a shed. I think we had one that had a couple of trailers for storing something on the property, but most of them actually don't have anything that's permanent, and we are not currently proposing anything on this project that is a permanent operations and maintenance type facility.
Directing your attention back to the CU plans, C-102. Top left, C-102, top left corner. Proposed,
Yeah, I completely misspoke. If there's a proposed O&M building, very rare, but yes, there's one on the center. I apologize.
for the record, you said there is a proposed O&M building.
That's correct.
How is that depicted on the plans?
It's just a rectangle.
Is it on any other site plan number? Does C-102 connect on the left side or the top side to anything?
I'm sorry, you mean connect as far as the adjoining plan sheet?
Yes.
Yeah, C-102 on the plan view top would connect to 101.
Where does C-101 say connect to 102? I think the word is match line.
On those plan sheets, I think because of the aerial underlay, the dashed matching lines are very faint. I can see like a really faint gray dash.
That's fine. But looking at C-102, I see the red line that depicts the proposed project area, and above to the left is where it says proposed O&M building. Is the proposed O&M building in the project area or outside the project area?
In the project area.
Okay. I don't mean to be dense. Where's the item that depicts the building within the project area on C-102? I see in white it says proposed O&M building, but I don't see within the red line project area.
I can see it on my copy. I don't know if there's a plot.
Oh, that's it?
Yeah, I thought. This is probably really small.
Okay, I'm with you. I thought that was in the verb. Okay, so it's within the project area. Underneath where it says proposed O&M building, it says property line and then parentheses TYP. What is TYP?
TYP is typical. It's a way to call out something that appears on a plan sheet over and over and over again without doing it over and over again.
That's why I'm not an engineer. Okay, thank you. Wikipedia didn't have that. Okay, so as far as you know, there's only one designated operation maintenance area.
As far as I know, that is.
Now, and you don't know if that's something solely for staging during construction, Or is it something that will exist during the operation of the facility?
As shown would be permanent. Anything that would be staged for construction and not permanent would typically be shown only on an ENS, an erosion sediment control plan, and then removed from anything for the post-construction condition. So this is shown as a permanent for the project life proposed.
Paragraph number 8 of the narrative begins, gated access roads will be located throughout the site for construction and maintenance of the solar facility. How many gated access roads are proposed?
Well, all the accesses will be gated. Again, I could count them off if you'd like, but everywhere where there's an access depicted that connects with a public street would be a gated access.
And they'll remain once the facility is constructed.
That's right.
The rest of paragraph 8 discusses fencing. The solar facility will have an 8-foot ag-style fence surrounding the site. Is that depicted on the conditional use plans?
So the fence is shown, give me a second. So to keep this easy, I'll go to C101. And there's a line with every inch or so, inch and a half or so, an X around the perimeter. That is meant to depict the location of the fence.
Okay, so under site legend, so what that legend you just described is for the proposed security fence.
Yes.
Okay. So that legend and that symbol shows up throughout.
I see it on sheet 101, but it should be the same throughout.
Okay. What is an ag-style fence?
An ag fence is typically going to look like, instead of, say, metal post and mesh, that you would see the chain link is more like a wire, typically like a 6-inch opening wire mesh with wooden posts. Most of our clients prefer to try to use an ag fence, so it looks a little bit, more like a lot of other agricultural properties would have some kind of fence around it, versus having, aside from the substation, of course, as you can see, barbed wire, as opposed to having chain link fence with barbed wire, that kind of thing, that would make it look much more industrial or unnecessarily aggressive.
What is it made of?
So, like a weld wire mesh, I understand, like a 6-inch by 6-inch grid.
That's an ag-style fence?
Yeah.
Does an ag-style fence that surrounds the site inhibit the habitat for small varmints?
So it can. What we typically do on projects is, well, a couple of things. One, of course, the openings for certain small creatures can kind of sneak through. In some cases, we've been asked by either our client directly as a proponent of the project or by local authorities to consider having something like a small gap where essentially the fence doesn't go all the way down to the ground. And that's done specifically to allow some native animals to be able to continue to presumably migrate the way that they are now or have been. I can't say that's something that we've talked actively about here, but it's something that's very common and something that we would certainly consider should it make sense to accommodate animal traffic.
It says the fencing will follow the standards of something called the National Electric Code, NEC. What are the standards in the NEC for ag-style fencing?
I don't know that there are any. Now, I'm not going to go into, I'm not an electrical code official, I'm not an electrical engineer. I know, I guess, a couple things. One, I believe the zone is for it to be 7 feet tall. I do not know offhand exactly what is and is not allowable from a material perspective. So I can't fully answer that. I just know that it's been accepted on many projects that are subject to electrical code review.
It also says there will be an 8-foot tall fence with barbed wire securing the proposed substation. First of all, I thought there was 2 substations.
There are 2 pads for substation use. Again, I understand that typically the substation and switch yard, but yes, the singular form probably is something that should be multiple.
And is that depicted on the plans?
The fence,
Yeah, the substation is, but is the 8-foot tall fence with barbed wire? I don't see it in the legend.
it does not appear to be depicted unless I can't see it under the hatching.
Well, wouldn't it be in the site legend if it was depicted on the plans?
It could have a separate hatch. Typically, fencing just has a fencing hatch, but I don't see it on the way. I don't see the fencing specifically called out, as it certainly would be ultimately be required as a separate fencing around those areas.
Are the standards in the NEC different for the 8-foot tall fence with barbed wire securing the proposed substation from the ag-style fence surrounding the site?
I don't believe so. I don't know definitively.
Turn to page 11 of the narrative, paragraph 31. You with me? All mechanical equipment at the solar facility, including any structure for batteries or storage cells, is proposed to be completely enclosed by a minimum 8-foot high fence with a self-locking gate. Is this a different fence from the 2 we've just discussed in paragraph 8?
I don't think so.
Okay.
I don't think we have a need for anything different than the ag fence on the perimeter, and for any other equipment, the same fence with barbed wire.
Reading the rest of paragraph 31, it references Exhibit 2, which I believe are the CU plans. It then says there will also be an 8-foot tall fence with barbed wire securing the proposed substation. And it also says, in addition, the solar facility will have a farm fence surrounding the remainder of the site. So paragraph 31, it would appear, describes 3 different fences. Is that accurate?
It appears to describe a fence that doesn't necessarily have barbed wire, and presumably the same fence with barbed wire, and then the farm fence or the aforementioned ag fence.
What would be the mechanical equipment at the site? Is the substation considered mechanical equipment?
So it's talking about batteries and storage cells, which, unless I'm missing something, are currently proposed on the project. Battery storage is a whole separate thing. So
I'm sorry, are not proposed.
as far as I'm aware, they're not proposed, but that's also something to be candid about. The industry is in flux on almost all of our projects as far as whether the facility will have battery storage or not. Nuance of the industry.
So we don't know if there's going to be battery storage associated with this project?
We don't have it proposed, that's all I know.
Back to the CU plans, if you'll, after site plan number 7, the next plan is called Site Details 1. You with me? Yeah. Top of the page, number 1 in a circle says typical fencing detail. And I'm assuming scale NTS means not to scale?
That's correct.
Reading from the left on the bottom, unless otherwise identified on plan, all fence shall be color coded. What's color coded fencing? Is that the ag style fence or is that the barbed wire fence?
That, I believe, is referred to like a coating, like you would see on a chain link fence that appears to be like rubberized, almost.
The color code.
That's all I got. Yeah.
Okay.
Well, it could be, I guess it's a color, but a lot of times it's just black or sometimes it's white. It's color. I don't know what the intent would be for the color.
Okay. And in the middle, it says verify with site plan. And I see a whole bunch of different numbers there. What do those numbers, never mind, those are reference notes. To the right, it says 50-foot wildlife fence raised section. What's that?
That's what I was referring to earlier as the sort of designated area that critters can pass through. Again, exactly how and where they're placed, but that's a general idea of something that we've had on other projects where the bottom is raised up.
50 feet length, not 50 feet height.
Right. And to be clear, so it's not I can see confusing on the plan. That doesn't mean that those two posts would be 50 feet apart. That would probably be a little bit too far for a fence.
And how many of these 50-foot segments will appear around this property in order to protect the critters?
I don't know, and again, on other projects, others have been involved to advise wildlife experts on how and where to place these, and that's a general detail for once that happens, the contractor knows what to do. I can't tell you how many there would be or where they would be located.
Were any wildlife experts consulted in order to prepare these plans?
No.
Paragraph 9. The solar facility, I'm back to the narrative. The solar facility will include lighting for security purposes. Is there a lighting plan?
There is not any lighting plan. I don't think so. No.
Next sentence says the lights will utilize motion sensors and will not be illuminated when not needed. Is that second sentence referring to the lighting for security purposes or something else?
It is referring to lighting for security purposes, I believe. My understanding is the owner's intent is to have, for instance, motion sensor lights so that if they say a maintenance vehicle needs to approaches the site and it pulls into a driveway at whatever proximity that would be, the light would then kick on, but not be on all the time.
So the lighting for security purposes will be dark unless something triggers the motion.
Right, it'll be off. I would say yes.
Next sentence, the main access gate. Where is the main access gate?
Good question. believe we would be talking about the substation side, which, as I understand, is the only critical infrastructure that would require having some lighting on, similar to how it's described in the main access gate.
Pick this,
Limited night, but be downcast.
which one are you looking at?
Oh, I'm sorry, I'm just looking at the index plan, but I could, so now on 105, just generally looking at the entrance that would lead into where the substation has room.
Okay. I'm on C-105. Towards the top, I see proposed project substation, and I see 2 black squares. Those are the 2 substations?
Yes, and needless correction, it's kind of a black and white hatching, probably looks black on the smaller plane.
Okay, but those are the substations.
Yes.
And to the right, it says proposed driveway. That's what's being considered as the main gate?
Again, as far as I know, I don't believe we have, I don't think something's labeled as main gate.
What road is that proposed driveway off from? My copy's too small to read the name of the street there.
This is moving, isn't it? This is where we're at. Is that crossroad? That's close.
Oh, I'm sorry, what was the answer? What?
I'm sorry, it's not labeled right on that, it's like a continuation of Cloud Street.
Okay. Are there any other proposed driveways connected to any other roads, like Lyle, or any other road where there's residential dwellings? Or is this the only access to the solar field?
So if you'll humor me, I'll name them. So the sole access proposed to the Frederick site is on Monument. There are
We're looking at C-101, I see proposed driveway on Monument.
yeah, I'm looking at 100 for kind of a one-stop shop here. There's a single access on the south side of Gaspar and Hess. There's another single access on the southern, I guess we call it southwestern portion of Gaspar off of Sunday.
Anything off of Route 22?
Sorry, I'm looking at 107.
That's okay. Without getting hung up on the number, It says on paragraph 9, the main access gate to the site will be illuminated at night. Will the other proposed driveways also be illuminated or only the main access gate?
So only the main access, the other gates would be, as I described, as motion activated, that would only be tripped, if you will, if a vehicle approaches.
Is the gated access road off of the existing local roads? Do you have to enter the access road before you hit the gates and the lights? Like, is there a setback? Or when you're driving down Monument and you want to turn into the site, there's a fence right there with lights, and you can't turn in unless you know how to get in.
So the short answer is yes, there's a setback. I'd have to kind of go one by one, but I can guide you generally with the dimension, but the intent was to have a car, or more likely a maintenance truck or some kind of pickup truck, would be able to pull off the road and get out and do what they got to do over the gate.
But local traffic driving by doesn't trigger the motion.
Well, I'm comfortable testifying that the alternate light fixture and control system will be selected to not allow that to be the case. I just don't design like controls.
Those gates are motion sensor lights, not permanent illumination. Only the main gate,
Right.
which will have a sign.
Right. Well, I presume it will have a sign. I don't think we have a project sign per se, aside from the electrical, like required code signs on those fences.
Okay, but the gated access, they're all locked, right?
Right. And yeah, required to be locked.
And is a key required to open, or is it a pad with a number?
I don't know what the control mechanism will be. I know that there's going to be two sides to that coin. One would be the owner's operations and maintenance, as far as what we would like to use, but then of course in conjunction with emergency services, whether there's going to be a Knox box or some other kind of keypad entry. I do not know what the access control will be at this time, but certainly would have to be coordinated with local services as well.
But once it's operational, there is no one manning the site.
Right. My understanding is that it would be in some proximity as far as having someone who's on call should the SCADA system say, hey, something's wrong, get over here, but not on-site personnel.
But the fire chief or fire marshal will have access to the code to enter,
Yes.
and the police department?
Yes.
Mr. Clark.
It is a good place to break.
Thank you. We're gonna take a 15-minute recess at this point.
I see a legend for township SWMO, I'm assuming that's stormwater. It says 50-foot stream buffer. Then there's another that says township ordinance 25-foot wetland buffer. That's not the buffer that's more like a setback.
That's correct.
Okay. Is there a buffer plan?
The buffer plan is really just what's depicted as far as the green shaded areas around the perimeter, certain perimeter areas of the site. At design phase is when a more formal landscape plan would be developed. But what you're seeing here on the overall site plan, the other site plan sheets, is a depiction of the proposed buffer locations as currently conceived, which of course would be subject to review and potential adjustment with the township engineer.
Paragraph 12 talks about noise. Applicant's exhibit number 24, if you could pull that up, please.
Okay.
This is a document dated December 6, 2022. This was prepared by your firm.
Yes.
Did you review this document before it was submitted to the client?
Yes.
It's identified as a memoranda on the exhibit list, but the subject matter calls it a sound study. Would you believe, is this a sound study or just a memo?
I believe the document is in, I don't even know if I would call it memo form, I'd probably call it letter form, but let's call it memo form, that reports out the results of a study.
And its conclusion?
Bear with me, there is a conclusion section.
Page 8.
For sake of not reading every word here, I'll skip to the second page, the second paragraph. After modeling and analyzing the anticipated operational sound levels throughout the proposed solar site, it was determined that noise mitigation measures are not needed at this time, since the anticipated operational sound levels will likely remain below the Windsor Township zoning ordinance maximum permitted sound level of 60 decibels.
Did the study analyze noise during construction?
It did not.
The software that was used for the study, I believe it's called Sound Plan.
That's right.
Have you worked with this model before?
I have not. I understand that it is the model that we use for all of our sound studies for projects similar to this, or projects such as warehouses or industrial uses, those kind of things. I do not personally work in the program sound plan.
What modeling assumptions were implemented in the model?
Again, I didn't prepare the study and I didn't perform the model unless you're asking me to read the assumptions.
Are there assumptions listed in the study?
There are assumptions as far as what is being added to the model, to as far as what is assumed to be the sound generation.
No, just turn to page 6. See where it says sound study?
Yes.
Does it identify the assumptions that were made in the use of this model?
It states simply that sound levels generated from inverters are anticipated to be the main source of sound.
That's what it says. But it also says sound plan, and plan is all caps, can also account for topography. Did this model account for topography?
It doesn't say that in this paragraph that it did or did not.
So you don't know.
I don't know.
Did it account for ground cover type?
I don't know.
On page 7 of the study, under inverters, based on typical noise emission levels for inverter equipment, a reference sound level of 79 dBA at 1 meter for each PV inverter was used. What's the source of that reference?
Unless it's listed, I don't know.
It's not listed, is it?
I don't know.
So if someone wanted to replicate the study and they don't know what assumptions were used, or they don't know the basis for this reference sound level, how can that study be analyzed, reviewed, or duplicated?
We can ask Tad.
I'm sorry?
We can ask Tad.
Ask TAD.
Yeah. This guy did the study.
TAD did the study. Is TAD going to testify?
I don't, not to my knowledge.
How many inverters were included in the modeling?
Looks like 15.
Where do you see that?
Page 8. I'm looking at the exhibit. Sorry, figure 4.
Where on figure 4 are 15 inverters identified?
Each, what would in some cases be referred to as a heat signature, represents a sound source, which is previously stated was assumed to be the inverters. I, of course, omitted the 2 squares, which presumably are the substations.
What is an inverter skid?
The foundation structure generally.
How many inverters are on a skid?
One, I believe. It's not my thing.
Is it your testimony that an inverter skid only contains one inverter?
It's not. I don't know. It's not my design purview. In other words, there probably could be more than one. I don't know.
Well, for purposes of the study, how many skids were included in the study?
It's, again, appears to be 15.
Because you're assuming figure 4 depicts inverter skids?
Yeah.
Is there a legend that says that?
No, the legend just covers the levels.
Under transformers, a reference sound level for a transformer of 75 dBA at 1 meter was used. What's the source of that reference?
I don't know.
What is the megavolt ampere, the MVA, expected to be located at each substation?
I don't know.
How many step-up transformers were included in the model?
I don't know.
Is there a collector substation?
Yes.
Was it included in the study?
I believe so, as indicated that there is a heat signature from the substation pads. Again, heat referring to sound.
So is it fair to assume this sound study is what's called a book study and has no relation to the actual proposed solar project?
I wouldn't say that, understanding that the equipment is representative of equipment that would be used on the site.
Pull out Exhibit 32, the stormwater study. looking at the cover page of Exhibit 32.
Yes.
When was this document prepared?
Dated October 18th, 2023.
Is that the date of the first hearing in this matter?
I don't recall.
If I told you that was the first hearing,
I believe you.
and that's when this exhibit was produced to the parties in the township, are you saying this document was not prepared prior to October 18th?
I'm saying simply that the document is dated October 18th.
Under page 1, section 1.2, general site description and considerations. Second paragraph, the proposed site improvements consist of ground-mounted solar panel on steel racks with driven W-section steel beams as the preferred foundation support, with crushed aggregate access roads and operation, maintenance, staging areas. We've already gone through operation, maintenance, staging areas, and you only identified one. Why is there plural operation, maintenance, staging areas in the stormwater?
You're correct. I'm only aware of one. So there would not be a second permanent operation in the staging area.
So,
Yeah, well, let me slight rephrasing. There's certainly one depicted designated operation made in the staging area. Technically, gravel areas or aggregate areas around inverters are also places for trucks to park. Parsing a bit the plurality, but there is, as you know, one permanent designated labeled operation in the staging area, but many locations that would essentially be used for the same purpose.
so walk me through the construction process. Take the,
The staging wouldn't be for construction. This is.
that's fine.
Okay.
So take the Gisberry property, you want to come in and you want to install an array of solar panels. What do you do to the existing field before you put the solar panel in?
Well, depending on what the final design depicts, there would be either areas that don't require any grade adjustment, and they would be left alone, and then ultimately reseeded with the permanent ground cover. Other areas would require some level of grade adjustment. So those would be stripped and graded, topsoil replaced, and seeded as the rest of the site would be.
Okay, let's talk about where you don't have to regrade. Flat surface land, you strip the soil, right?
No, you don't have to.
You just,
If it's not designed, if it doesn't need to be regraded, it certainly wouldn't strip. And there will be grading on the project for sure, to some degree, again, subject to final design many moons from now. But on sites and on portions of this site where grading is required to meet the slope tolerances of the equipment, there certainly is not any need to arbitrarily strip the topsoil, and it would be, you'd want to leave it, frankly, so as not to create any unnecessary disturbance.
what's the number of acres that are disturbed by the installation of the solar panels?
So there's two answers to that. One is, well, there's three answers. One is that's all subject to much future final design. The second answer is, as far as the conservation district is concerned, and PADEP, everything within the limit of disturbance, which is essentially the entire project site, will be considered the limit of disturbance. I air quoted there if you have it. But that doesn't mean that everything will be stripped as part of the project. They simply require the LOD, as we call it, to encompass the project activity area and all erosion controls and so on.
It says stormwater runoff is directed to adjacent stormwater VMPs. A VMP, that's the best management practice?
Yes.
And what are the VMPs for this project?
So as currently conceived, again, a long way to final design, currently conceived is what's called dry extended detention MRCs, which is an acronym for management use concept. And if I may preface that the purpose of generating a report in the first place, while it's not required for conditional use, was at the suggestion of the township engineer, so that he had an understanding of what stormwater might look like conceptually, and whether we could essentially meet the requirements of the ordinance, again, in concept, based on the panels being considered impervious area. And so that was the basis for putting the study together. So in doing that, there are some factors that still have to be added into this, like for instance, geotechnical investigation, lots of things that happen much beyond conditional use or any use phase. So what we did was use these dry extended management release concept facilities, which create, in our view, a conservative design where you're not assuming that you're getting credit, say, for infiltration of stormwater into the ground, into the groundwater, and you just have the surface facilities that collect and then slowly release the discharge. And again, that was the premise of the study and why we modeled with these dry extended release management concept bases.
So for purposes of conditional use, your intent is not to meet the requirements of the stormwater management ordinance, correct?
It's not our intent, it's just not a requirement because it's a land development. But we've demonstrated the ability with facilities such as these to have the appropriate rate reductions and volume, meeting volume requirements of both the stormwater management ordinance and chapter 1 and 2, which would be required for NPDES permitting. But again, all done conceptually and preliminarily at the behest of the township engineer.
What's an amended soil?
An amended soil is when existing soil, or in some cases imported soil, but in most cases existing soil is amended with certain additives. Those additives usually come in the form of things like compost, or in some cases sand, to increase the porosity of the soil so that rainfall will have more propensity to be essentially soaked up by the topsoil.
Do you have experience with managed release concepts?
Yeah, we have several on projects.
Are you familiar with DEP's guidance on managed release concepts?
Generally.
Does your proposed stormwater management plan meet the applicability requirements for MRC?
Well, as I mentioned before, there's requirements for geotechnical testing. So for instance, there would be a need to do a spread of soil infiltration testing throughout the site, and subject to the results of those requirements, MRC may or may not be appropriate. Again, we use it as a preliminary study since the basin sizes usually end up being a little bit larger, since the release rates are controlled to be a little bit slower. Therefore, we use it to make the design a little bit more conservative. May or may not be, even from different portions of the site, exactly what ends up being implemented on the project. You're absolutely correct. It would be subject to meeting the criteria that DEP set forward for MRC deployment.
You're not able to testify that the project as proposed in Exhibit 32 meets the applicable requirements for managed release concepts?
I'm not able to testify that it's applicable to conditional use.
But it's the entire basis for your stormwater management in Exhibit 32, is that correct?
It's the basis for a conservative conceptual design that we did to satisfy some upfront curiosities of the township engineer.
What is the number of acres that are being recreated?
I don't have that exact number, and again, it's even the grading plan we have for conditional use, as it's a part of engineering, it's not required for conditional use, it's purely conceptual, and would be subject to change through engineering. That's a combination of civil engineering and structural engineering for all solar projects to try to optimize and minimize grading. And so therefore, as it is so conceptual, we don't have a hard number of exact acreage currently depicted as proposed for grading.
Page 2, under methodology and parameter development in Exhibit 32, you talk about time of concentration on the bottom or the middle of the page. You see that?
Yes.
Did you walk the time of concentration travel paths for each of the 14 drainage areas?
I did not.
Was that done in order to prepare the report?
To be quite blunt, I have never known anyone to walk a time of concentration travel path, and I'm sure someone has done it. I have never heard of anyone doing that.
The Department of Environmental Protection frequently asked questions. The FAQ document, which I believe is Exhibit 10. We already identified in your prior testimony that the stormwater management report cites the wrong version of that document.
That's correct.
Okay. So looking at the correct version, revised April 30, 2021. You're claiming that you meet the requirements under FAQ number 4.
Thank you.
I'm sorry.
No.
No? Oh. Okay. What's your position on the DEP guidance document?
Under FAQ 4, I guess it's not second paragraph, it would be the second, the first sentence under the two paragraphs. If these criteria cannot be achieved, please refer to FAQ 5. FAQ 5 very simply states that if unable to meet all the criteria in FAQ 4, the applicant should have their licensed professional determine the need for additional post-construction stormwater management BAPs by completing a stormwater analysis to determine how the proposed solar farm will impact the rate, volume, and quality of stormwater runoff from the site. So essentially, FAQ 4 provides criteria where, if met, if you go back to page 3 at the very top, if the project will meet all the criteria listed below, stormwater runoff may be considered mitigated through the preservation or restoration of vegetated ground surface, thereby satisfying the PCSM requirements pursuant to 25 PA Code 102.8N, and a detailed stormwater analysis will not be required. So we're obviously starting to do and intending to do a detailed stormwater analysis. So per DEP's guidance, we meet the guidance simply by skipping FAQ4 and going to FAQ5.
So your stormwater study says solar panels are considered impervious as per the township zoning ordinance. Do you agree with that?
Yeah, we were required to consider the panels to be impervious for the ordinance. Yeah.
Does your stormwater report propose any infiltration?
Again, it doesn't currently, but that doesn't mean that at the conclusion of an appropriate spread of geotechnical investigation, that it wouldn't be considered.
Did you perform any infiltration testing?
No.
Are you proposing any pre-treatment facilities prior to detention and retention basins?
At this point, no. We do certainly consider that in some cases. But also, one of the things that we look at on projects like this is that so much of the stormwater is going to run through these deeply rooted, dense perennial meadow bricks, or whatever the landscape architect wants to call them. And there's an awful lot of water quality benefit that happens from those, and also that different from, say, a parking lot where you have material that comes off of tires and gets washed off and run into the grass. What comes off of solar panels is, maybe little bits of particulates, but basically rain falling on glass and then falling on the ground. So there's not typically a need for special, if you will, pre-treatment, whether that be surface facilities or some kind of chambers that treat the water beyond what you can get out of grass or filter strips or just running into the detention facilities themselves. And with those types of facilities on other projects, we're certainly able to meet the water quality requirements that are under DEP's code and whatever mainstream ordinance that we're working under.
Paragraph 14 of the narrative talks about a point of interconnection. And it will connect to the electric grid. It says that a new public utility-owned substation located approximately 1/2 of a mile south of the intersection of Old US Route 22 and Klaus Road and owned by Metropolitan Edison. Is this proposed public utility-owned substation part of the project?
I'm sorry, I don't know what page, you're not on this one.
I'm sorry, page 4 of the narrative.
Oh.
I'm sorry, I was done with school.
No problem.
Can you identify the exhibit, please?
It's the narrative, exhibit 1.
440 exhibit 1, thank you.
And I'm sorry, you said page.
Paragraph 14 on page 4.
Yeah, so again, my understanding is that there's the two substation pads. One is project owned, and the other is this the one that's referred to as public utility owned. I'm not aware of any other out of project or off-site substation.
Okay.
If that makes sense.
So one of the two substations depicted as part of the project, within the project area, is going to be publicly owned by Metropolitan Edison.
That's my understanding, yes.
What are the terms and responsibilities for operation and maintenance of that substation?
I don't know. I imagine that would be a good question for the owners.
Paragraph 15 talks about the first year of operation, and it says the amount of energy produced is enough to power nearly 8,500 average U.S. homes. Let's be clear. Is there any local benefit to the generation?
Objection. This is really outside the scope of his testimony. He's already testified that he did not prepare the narrative, and this is outside of the scope of any study that they proposed.
I think I'm going to overrule the objection, because if that's the case, he can say he doesn't know and move on.
I don't know.
Did you read the question back before you didn't know?
Paragraph 15 talks about the first year of operation, and it says the amount of energy produced is enough to power nearly 8,500 average U.S. homes. Let's be clear, is there any local benefit to the generation?
Answer, I don't know.
I can't track the power through the wire, so I don't know.
That's fine. Paragraph 16 talks about the number of jobs during construction.
Same objection.
Mr. Hughes, did your company prepare a study as to the economic impact and the job creation that this project would create?
No.
The objection is sustained.
Does the applicant intend to call a witness to testify regarding the narrative?
Yes.
Okay. Paragraph 17, again, job creation, same objection, same ruling.
Yes. Yes.
Paragraph 18 talks about a lifespan of 50 years. Do you know the lifespan of this facility?
My understanding was that it was essentially a base contract of 40 years with an option for an additional 10.
Directing your attention to applicant's exhibit 11. Did your firm prepare exhibit 11?
Yes.
Did you review?
Yes.
Actually, is that your engineering seal on the document?
Yeah, I can't document this with that.
Turn to page 3 on the bottom under restoration of property. Bottom of the page, continuing on to page 4. Mass grading is not anticipated since the initial project will not alter topography significantly. How do you define significantly?
I do not have a metric for significant.
But you already testified you don't know the number of acres that are going to be regraded, do you?
I mentioned this earlier, it's a dovetailing of civil design and structural design to balance of minimizing earthwork, and the structural side of it is to minimize but optimize the amount of steel going into the project, in other words, the depth of the piles that need to be embedded. And again, the intent is to minimize that. But the direct answer to your question, I do not have a metric for significantly.
Does your estimated cost include site remediation?
I don't believe there's an item titled remediation. But remediation is a big word, which, in what regard?
What do you think it means?
You asked the question.
Well, on your chart, on page Exhibit A, you have an item, $2,000 for contaminated soils testing. So assume the contaminated soils testing sample results come back with exceedances of parameters of pollutants in the soil. Do you have to remediate that? Meaning clean it up?
In that hypothetical, presumably there may be, depending upon the levels, I'm not an environmental remediation expert, but presumably that may require something. But
Page 4, decommissioning cost estimate and financial security, second paragraph. Windsor Township zoning code requires Mountain Trail Solar LLC post a bond or other financial security in a form acceptable to the township at the time of building permit issuance to cover the cost of equipment removal. Is that an accurate sentence?
I believe where you're going to go with this is the part of the ordinance that says at the time of zoning permit, or something to that effect, as I may have read. Is there anyone else?
I'm asking you, is the sentence accurate?
Yeah, that is typically when the bonds are posted, because that's when the project's been designed, that's when the estimates can be fully rectified. But I do recall reading in the township's ordinance something related to zoning. So if it's building versus zoning, it may be of a strictly ordinance perspective inaccurate. Procedurally speaking, that's when bonds are issued.
Yeah, but you said the zoning code says this. So are you making false statements under your engineering certification?
I wouldn't call it a false statement.
Oh, it's not false. It says the zoning code. Where in the zoning code does it say at the time of building permit?
I don't have the zoning code in front of me, so.
Let's pull it out. Did you review zoning code in order to prepare and certify this document?
I've reviewed the zoning code generally over the course of the project. I can't necessarily say I specifically reviewed the zoning code on behalf of the decommissioning of the plan itself. We prepared a decommissioning plan based on the understanding that one was required, and as also prompted by reviews from the township engineer to prepare a decommissioning estimate so that he and the township would have an idea of what that looks like, but to presumably be prepared after the project's designed, which is again many years away.
Section 615, parentheses, parentheses closed, says at the time of zoning approval. That's not what the zoning code says, is it?
It's not, no.
So you're still defending your position that you read the zoning code and that it's correct that at the time of building permit?
It's not what the zoning ordinance says. Exactly, I'm not arguing about what the zoning ordinance says.
But you got it wrong. That's what I'm trying to understand. You sealed this document. You claim the zoning code says something. You're representing to the township
Objection, this is getting argumentative, he's answered the question.
Mr. Clark, I believe that the question has been answered. You can move on.
Did you review the township engineer's October 17 letter?
Yes.
And do you have a response to his comments about the decommissioning plan?
So while we haven't issued a formal response, I'm able at this point to address the elephant in the room, which is the value. We've had several decommissioning plans, both in Pennsylvania and other states, where, as noted in the decommissioning plan, we use RS means data. And RS means is simply an organization that aggregates construction data to provide construction costs for typical activities, and we assign those unit prices to quantities that were taken off in the plan. So we're not aware of, but certainly not willing to engage in discussion and at the appropriate time come to an understanding with the township engineer about what an appropriate bond value would be. However, we haven't seen or frankly received any pushback on call it the order of magnitude unit prices that we've used on other projects, at least not in the order that the township engineer is suggesting, which to say I believe is somewhere in the order of tenfold.
Did you review the Department of Energy's National Renewable Energy Laboratory document titled Best Practices at the End of the Photovoltaic System Performance Period, published in February 2021?
Are you referring to the reference from the township engineer's letter?
Yes.
I did look at it. I cannot claim to have read it word for word, but I did look at it to at least understand where the data was coming from. Again, I can't presume to agree with, nor rebut that data. I would need more information and time and so forth to actually understand how, for instance, that data may differ as far as project size or the type of work being proposed. I don't know, but I did take a look at it just to kind of confirm where Steve got that information from.
Before you prepared the decommissioning estimate, did you review any other decommissioning estimates from any other projects?
Just our own, not, and again, I can't necessarily speak for everyone on my staff that may have touched it, they may have pulled different resources. I'm not aware of having pulled in estimates done, say, for other projects by other companies, only that we have other estimates that we've done and we draw on as resources when we do, the next estimate.
When you sealed this report, what other estimates did you rely upon?
We didn't rely upon, I wouldn't use that word, it's just we have other estimates that we've done, so we can pull that out as a starting point to have common, similar items, and then as long as not too much time has gone by, one factor where you might increase prices if an estimate was done 5 years ago, but all the estimates that we've done, this is a very young industry, have been done probably in the last couple of years, so everything that we would have is relatively new data.
Paragraph 19 of the narrative review section 403 of the zoning ordinance?
Yes.
What is the maximum building coverage set forth in section 403 of the zoning ordinance?
20%.
And what does the chart on page 5 indicate for maximum building coverage?
20%.
How many times is maximum building coverage identified in this chart?
It's identified twice. The second one presumably is the maximum impervious coverage.
So the chart is also not accurate,
That appears to be the case.
but you didn't see the narrative before it was submitted with the application?
I'm on the project team. I didn't see that item as being duplicated.
And did you see the narrative before it was submitted?
Yeah, I didn't review it in detail, but we worked on it as a team in a sense.
But you saw it, you're familiar with it,
Yeah,
and you didn't catch another mistake in it.
It appears to be the case. But I'm not in charge of reviewing the narrative. So.
How, well, for what purpose would you have reviewed the narrative? Didn't you review it for accuracy?
I don't know where you're going with that. It's not a document that I prepared, so.
Why did you review it?
I'll go ahead and take back the artwork. I'm not reviewing it in a way that the engineer would review plans, so.
How did you determine the percentage of lot coverage for each of the lots?
Basically using AutoCAD to do what we call quantity takeoffs of the panels, roads, inverters, and the like. And then essentially that takeoff over the overall lot area is your percentage of coverage.
Where is that depicted in the plans?
That's in the chart for the dimensional standards. On the right side, we'll choose the overall C100. The chart on the right side, on the rightmost kind of pair of columns, headed by one word proposed, and then it splits into the two tracks. One says goes far on the left, Frederick on the right. And if you go down 5 rows or so, then you get to the two items. One is for building and one is for the impervious, which is essentially overall. And building certainly understands, since this was a zoning issue from the early stages of the project, is essentially the panels. The panels were interpreted to be buildings, essentially little roofs, and so that's what the building coverage is.
When these determinations or calculations were made that you just referenced, did all 3 of the Frederick lots propose to have solar panels?
Yes.
So what percentage of impervious coverage is there for each of the 3 Frederick lots?
So it's calculated as an overall tract, and my understanding is that this is something that's been brought up before, and our position is that if a lot consolidation is necessary, then that's something that the applicant's willing to do. I think that one thing that we've seen on most of these solar projects where there are many in the state that have arrays that cross what we would call internal lot lines, is that the internal lot lines don't factor into the project from a lease operation, and these are going to be zoning and legal issues that go outside of my realm, but that is my understanding of the applicant's position. And again, it's not depicted with those 2 additional lots shown, and if a consolidation is necessary, so it's something that could easily be taken care of during subdivision and land development.
page 6, paragraph 21 of the narrative, exhibit 1. Do you know what the NFPA is?
Where are you? National Fire Protection Association? You said 21?
Yeah, and well, 21 just talks about applicable standards. I'm asking you about NFPA.
I don't see that. Is it been referencing it?
No, the 21A is what the ordinance talks about.
Yes.
Design, installation, operation, and maintenance shall conform to applicable standards. Is NFPA 70 an applicable standard?
Likely, I'm not a code official.
Okay. If NFPA 70 says a solar energy facility of this size is considered an industrial use, would that still be an applicable requirement?
The standard as a whole, or the?
NFPA 70, are you familiar with it?
No.
Okay. In preparing the design of this project, the conditional use plans that are there, did you take into consideration its proximity to the Hawk Mountain Sanctuary?
We were made aware of concerns, but the project is where it is. So I didn't take into consideration proximity to Hawk Mountain as something that would create a design adjustment. The site is located where it says located.
And does the proposed site have an impact on the migratory pattern for birds?
Way outside my purview.
Do you know whether or not a permit is required under the Migratory Birds Act?
I don't. All I know is that we submit a project search to the Pennsylvania National Diversity Index as required, and that's what tells us any issues that any project has with threatened and endangered species, whether they be animals or plant life, and then we react accordingly to that process. And in doing that, migratory birds, or specifically red mountain or Hawk Mountain, if it didn't come up, and it would not be presumably required under or for any regulatory permits for the project. But outside of that, which is usually a PADP kind of governed thing, I don't know if any other permit would be required. It's not something that I've ever dealt with migratory birds.
Does the PNDI address the migratory patterns for hawks?
I cannot say that I know for sure if those searches take that into consideration. My understanding is the primary emphasis is habitat, but I don't know all the details of what, let's just say, what the algorithm is going to look at when you put in your project area.
Did you see the letter from the Hawk Mountain Sanctuary about this project?
I know that it exists. I honestly couldn't tell you exactly what it says.
Okay, you haven't read it.
I don't recall reading it now.
21B of the narrative, it says, commercial solar energy systems shall have a minimum lot size of 5 acres. Do each of the 5 lots have a minimum lot size of 5 acres?
Well, again, with respect to the Frederick parcel, we're looking at that as the energy system is the overall project area. And again, if there's an issue with lot sizes, that the lots would be consolidated.
As of today, as of the submission of the application, all 5 lots do not meet the minimum 5-acre requirement.
I just saw a chart with the individual parcel. Sorry. can answer your question. Um, It appears that two of the lots are 1.06 acres and 1.01 acres. So as currently comprised, the individual lots are not all at least 5 acres. And again, I'm sorry, I'm referring to the Exhibit A associated with the Frederick property within Exhibit 2.
Yes, let's take a 5-minute break so I can see if I have any more.
We'll take a 5-minute recess. Mr. Clark, you may proceed.
Mr. Hughes, the conditional use plans identify existing slopes of 25% or greater. Why doesn't the conditional use plans include slopes between 10 and 25%?
The plan, it shows the 25 simply because that was what was called out specifically by the township engineer as a point of concern. We understand and are willing to and able to comply with the item in the code related to, I believe it's 15 and 25, I believe it's 10 and 25. It was not a deliberate omission. Again, it was simply to highlight the 25% slope areas that were specifically called out. I don't remember the date, but one of the review letters from the township engineer.
Existing slopes between 10 and 25%, do they have to be regraded in order to install the solar panels?
That's not really how it works. The analysis that's performed for grading for solar has very specific requirements for north-south slopes, one direction, east-west slopes, the other direction. Frankly, it's a fairly complicated program that my company has developed to do that analysis. It's not just a what we would call kind of a raw overall slope analysis where everything over X percent needs to be flattened or anything like that. It's both directions. There's a measure of what's called pile reveal, the distance from sort of panel edge to the ground, and there's a tolerance for that that's based on manufacturer spec, maybe plus or minus 12 inches or 18 inches or something like that. I apologize for not having a super direct answer. It's very complex. It's not just a matter of overall slope requiring some correction.
You don't know how many acres need to be regraded in order to install the panels?
That's correct. That'll be determined on the final construction plans after electrical design, structural design, after many, many iterations. I can assure you, not something that would be contemplated prior to having use approval.
If you don't know the number of acres, how could you opine that the regrading is not significant? Excuse me, that it is significant? Hold on. Strike the question. I misspoke.
I think you went the wrong way.
I was probably right the first time. Your reports indicate the amount of regrading is not significant. If you don't know the number of acres to be regraded, how can you make that opinion?
I wouldn't call it an opinion. It's more of it's an understanding that the design process is essentially designed, again, with civil engineering and structural engineering to work in concert to minimize grading. And the intent is to minimize grading. And if it's minimized, then one might argue that it's not significant. But again, as you had pointed out, I do not have a metric for significant either. But that is the intent. Again, that happens much further down the road. But that's what all of our projects do is marry civil and structural so that grading is done only where necessary and structural is there to balance out. And again, with the steel or length of piles, essentially to optimize the design. And that's all I can tell you at this point, at this stage in the engineering.
So you're also not able to conclude that you're minimizing grading?
I can't conclude anything because the engineering of any project like this happens many, many months from now and certainly after use approval.
That's all I have.
Thank you, Mr. Clark.
Subject to the very beginning of his testimony this evening about the topographic survey.
Thank you. Duly noted. Okay, so we have additional parties who may have questions. Ms. Bellata?
Oh, no, I don't, thank you.
Mr. Ballfazer?
No,
No questions?
I do have questions.
Okay. You may proceed.
Do you want to come forward to use the microphone?
to talk about Exhibit 37, the solar glare and analysis report. Okay, under assumptions, page 48 or 48, you mentioned that green glare is glare with low potential to cause an after image, flash blindness when observed prior to a typical blink response time. And yellow glare is glare with the potential to cause an after image, flash blindness when observed prior to a typical blink response. Figure 2, page 4 of the report shows red glare with a statement potential for permanent.
I'm just going to object, this is outside the scope of his particular testimony.
We're going to have an expert on.
We had one testify at length last hearing.
There was one at the last hearing. I'm just trying to, this is why I don't like to break up the testimony, because I am having a hard time recalling if during the initial direct, if there was any discussion. This is a report that was prepared by Kinley Horn. So at this point, I'm going to overrule the objection because I believe that it is it's proper for cross-examination, given it's a report prepared by Kinley Horn. Now, he may not know the answers to the questions you're asking, but I think you're entitled to ask them.
Okay. Okay, figure 2, page 4, the report shows red glare with a statement potential for permanent eye damage, retinal burn. Where is daytime sun listed in the color chart of red, yellow, and green?
So I'm going to issue a blanket apology because I'm not going to answer the questions about the glare study. I do apologize for that. Yes, it was prepared by Kinley Horn. I did not prepare it. I do not know how to analyze glare. I do not know how to run the program. And again, on behalf of our team, Mr. Cleveland, who was at the previous hearing, the intent was for him as an expert in a wide array of impact studies related to solar farms to testify to the results of the study. But I really don't know. I'm not ducking your question. I just don't know. I do not prepare glare studies.
Okay, so I guess I'm a little confused as to why this was a Kinley Horn study.
There's 8,000 people that work at Kinley Horn.
Right, but is this person, what was his name?
Mr. Cleveland.
Mr. Cleveland, is he an employee of Kinley Horn?
Mr. Cleveland is not an employee of Kinley Horn. He, as I understand it, was a solar related project impact researcher and specialist, and so he was called to testify on several topics, including glare.
I guess I just don't know where to go with this. I have questions about Exhibit 37. I was not aware that he was the expert. I don't know. I don't have an answer for that. But I have questions about this, about how this compared again. I thought it was Kinley Horn. I thought Paul was the, since he did not have his name on the study, I guess I feel like I was misled on that.
I think at this point, if the witness says he doesn't know the answers, we can't make him know the answers, unfortunately. I understand your frustration, however.
Yeah. I did have a couple questions I asked him, and he kind of moved along.
Do you have any questions on any other topic other than the glare study?
Well, the glare study was going to be my main topic here. I guess we'll go to the hold on a second. Okay, let's talk about the decommissioning estimate review. The exhibit Hey, Mr. Gluck asked so many questions that I was going to ask you to review this a little bit. Okay, so you're recommending a decommissioning bond of $1.163 million.
So the two numbers, the other one is $5 million and change. One is what we call with salvage, with some assumed value to the equipment. Frankly, I'm not recommending one or the other. My understanding also from even the initial review from the township engineer that with salvage, the lower number is going to be hard to swallow. So I don't think that, regardless of exactly what a final number would look like, my understanding is that there's going to be objection to using the salvage value. So it's probably more likely to be the larger of the two. But I don't know, that would be subject to certainly the final quantities from the more detailed design, and again, subject to your approval by the township staff and township engineer.
Okay, is it your understanding that this bond is to be used in case Mount Trail Solar goes bankrupt and that they're not able to decommission the site
So
in 50 years from now?
So my understanding of the ordinance is that it's, and forgive me, it's something to the effect of if it stops producing power for 6 months, essentially if it goes offline, and I think there's something in there about needing to demonstrate power production to the township if asked. But yeah, that's my understanding. Just like any kind of any construction project, you would post an escrow, a developer would post an escrow, and if the developer goes belly up, that escrow is there so that the township can not necessarily finish the project, but make sure that the site is safe and secure, this kind of things. So the decommissioning is in the same way that a site improvements escrow secures construction of the project. This is a mechanism to secure decommissioning of the project, which as you're alluding to, theoretically could happen at any time during the time frame, much more likely for it to be at the end of the project life. But that's what it's for, is to secure the township and make sure those funds are available. And forgive me for not being a financial expert, my understanding is that they need to be reevaluated and re-upped every 5 years so that they can kind of keep the dollars current.
Yeah, I think the ordinance calls for a 10% increase every 5 years. So, ran some numbers here. If in 50 years, the $1.1 million factor figure that you say would likely not be used is worth $2 million. If we go with the $5 million amount in 50 years, that 10% escalation, that amount would be $13 million in 50 years. So it's quite a bit of difference. And you say you had not seen the NREL that Mr. Klepp?
No, I did see it. I hadn't seen it prior to Mr. Hoffman bringing it to our attention in his review letter. But again, as part of my previous testimony was, we have done some estimates for projects in Pennsylvania. We also have some partners around the country within Kimley Horn who have done some estimates. So we're able to crowdsource to a degree, and we use the program I mentioned earlier, RS Means, that provides construction data. So again, I don't know We have to do some more research to figure out why there's such a wide spread between what that study is suggesting and many cost estimates that I've seen. But again, certainly that's something that has to be done in concert with the township and agreed upon, so that that value is, everybody's comfortable with it, because both parties are ultimately going to have to sign it and understand and agree that that security is going to be adequate if and when it needs to be called upon.
Okay, because compound interest makes a big difference.
Indeed.
When you're looking at 50 years, because if you look at the U.S. Department of Energy, they're asking for $15 to $20 million for this size project, for a 50-megawatt project. And $15 million in 50 years would turn into almost $39 million, and $20 million would turn into almost $52 million in 50 years. So we're talking going from $13 million to $38 to $51 million. It's a huge amount of money. It might make be the difference between actually decommissioning the site and not having.
Is there a question? I'm just going to check that that's asked that.
Is there a question?
No, not for that. We'll move on. Let's see. On your estimate, you have supervision at 210 hours at $77 per hour for a total of $16,170. So that would be on the actual estimate to exhibit A, I believe. What does that represent? I mean, 210 hours is only 4.5 weeks, 5.25 weeks. So is the decommissioning going to occur in 5.25 weeks? What are we looking at? Why do we only have that little bit of hours for supervision?
Yeah, I mean, that's an estimate. Think about, I'm trying to make a corollary here. Think about sometimes say a demolition phase of a redevelopment project. Like the demolition phase is like this, and then the construction phase is much, much, much longer. This is like as quickly as possible, taking a bunch of stuff away and then restoring the area. Again, I don't know if we had 5 contractors look at it and give us a schedule, exactly what they would say. But again, we had some other estimates for different size projects, and then prorated that, and then presumably the unit price comes out of the sort of staff section, if you will, worker section of RS means. It's an estimate.
Did you want to have a supervision on site for the entire project?
Presumably there would be, and again, it's a form that we've used for other decommissioning estimates. There's obviously other staff on site. We don't itemize every little bit of staff. All the staff that goes into the other items on the sheet are sort of cooked into the unit prices. It's just a form that we've seen used that for some reason pulls out supervisor.
How many construction hours are required to complete the construction of the solar farm? To build this solar farm?
I don't know hours. I believe, and I can defer for correction to the owner, who I believe is going to testify next week. But I believe we're looking at somewhere in a 1-year time frame for the project. You may say something like 9 to 12 months. I think I might have heard that before, but let's just call it about a year.
The tasks are a lot different for construction and deconstruction, because you talk about taking the panels apart. And again, we talk about this in the National Laboratories report. Disassembling these panels and recreating them, so it appears that you would be doing the same task to construct and to deconstruct, so there wouldn't be a whole lot of difference in labor hours. Do you agree with that? You're bolting something together, you're unbolting it. You're taking it out of a crate, you're putting it back in the crate. Does it seem like you should have similar hours?
Honestly, I really don't know. I mean, I think if you want to have a construction and decommissioning expert talk about the effort that goes into those things, that's fine. And to be honest, let's look at it this way too. We're talking about a project in the approval stage that may be decommissioned in 50 years. We also have numerous projects that we've designed, some of which have been constructed at this point. I'm going to be long since retired when we need to, as will you, I presume, when it's time to decommission one of these. So I can't say I've seen one be decommissioned because most of them are still being constructed. So I would defer that to a decommissioning contractor, exactly what that process looks like. So I can't really say as a, to answer your question.
Okay. All right, you have a line item here of seeding 16 acres. Cost of $34,031. But yet you have, it seems like most of the site would be disturbed by removing piles and digging up underground cable, backfilling AC and DC trenches. It states 3,860,500 linear feet of trench that needs backfill, a 3-foot wide disturbed area for 3,860,500 linear feet of trench is 266 acres. So why are you only seeding 16 of 450 acres? You know, are we turning this back into farmland?
I'm not sure we're getting 266 acres.
Well, it just seems like we're only seeding 16 acres, but yet we're restoring the entire property, the entire 400 acres.
Right, but the intent would be that the ground cover that's planned at the end of construction, as much as possible would remain, except for some of the strips where you mentioned the cables are, when the posts can be pulled out, and there's really nothing there. They get driven in and get pulled out, right? So not really a disturbance area. So there certainly would be no intent, just as there would be on the front end of construction, to strip any of the vegetation that was put in place when the project's built. So I believe that that's the intent of the seeding, is that there's going to be some restoration that needs to take place, but the bulk of the ground cover would be left in place. But again, certainly if there is discrepancies between the exact quantities on the final engineered plans, that would all have to be perfectly square, presumably before the township engineer would recommend, and the township would agree to the decommissioning estimate and the decommissioning line.
All right, you also have remove and recycle 134,004 photovoltaic modules at $5.55 each for a salvage value of $388,474. At what point does this panel turn from a salvage value to just scrap that needs to be landfilled? And
so
at that point, it would become an expense rather than salvage.
So let me preface this by saying this is not my field. However, I'm happy to offer what I've heard in working with developers and electrical engineers and module manufacturers, is that for projects that have been in use and for estimates for newer panels, that they expect that call it the efficiency of the panels usually drops from 100% to somewhere between maybe 80% or 70%, and therefore that's why they're looked at as potentially being salvaged or something that could be repurposed somewhere else and still get output. I can't say that's a rule of thumb, again, it's not my field, but I'm happy to relay what I've heard as far as how the panels, they do of course lose some of their efficiency, but unless the panel's defective, my understanding is it's very unlikely that it would drop to zero, even in that long lifespan. But certainly would love to have someone other than me answer that question more directly, but that's what I've heard.
Okay. I'm not going to questions except the logical point about not being able to ask questions about particular
Duly noted.
what would you do about that?
Mr. Solicitor, I'd like to raise a due process issue related to Mr. Ballheiser's request. Mr. Cleveland testified on October 26th. He arrived at that hearing with his own health and assessment report. On the same evening, the Kimley Horn glare study was introduced as an exhibit. We did not have an opportunity to review that study prior to Mr. Cleveland's testimony. He rendered an opinion in his expert report on health and assessment that he relied on the Kimley Horn report and its concluding opinion, and he gave an opinion about the Kimley Horn report. I think we should have a fair opportunity to cross-examine the author of the Kimley Horn report. And my question is, why isn't it sealed?
So, and just to respond to that, that is incorrect. We provided the Kimley Horn report far in advance. We provided it at the same time as we did the other exhibits before the last hearing. Mr. Cleveland testified that he reviewed the report. He also reviewed the data and the study that went into the report, and he could independently, just based on the studies, render an expert opinion on glare, which he did.
Who is the author of the Kimley Horn report?
It's not sealed.
Well, regardless, I mean, the transcript speaks for itself.
Mr. Hughes testified that evening. He was not subject to cross-examination. So we should have been able to assume, since we had to split his testimony, that we weren't able to cross-examine on this glare study of Kimley Horn and Mr. Hughes. Mr. Cleveland comes along the same evening and opines about the Kimley Horn report. I'm not questioning the Cleveland report. I'm questioning the inability to cross-examine the Kimley Horn report that isn't sealed.
Those materials were given before the hearing. He testified to them.
We did not have a chance to cross-examine on this document.
Mr. Gallagher, I'm still waiting for an answer to my question as to who the author of this report is. Do you know?
I believe his name is Patrick Butler.
Is it your intention to call Mr. Butler as a witness in this proceeding?
It is not.
Mr. Clark, is it your intention to now call Mr. Butler as a witness so that you can cross-examine him with regards to this report?
Assuming the applicant survives a motion to dismiss at the conclusion of their case in chief, I will intend to subpoena the author of the noise study and the glare study.
I will have to review the transcript. I can't tell you that I memorized like a detail of the transcript. I would welcome any parties who want to, on or before close of business on December 4th, submit a written argument based on the transcript, to do so by email. And we will have to address this issue. And it's preserved for consideration. But by no means, no, it's not mandatory that you submit anything.
Yeah.
I'm just saying that if you want to, you may. Mr. Hartman. Mr. Hartman says no. Mr. Hoffner, I don't believe Mr. Hoffner is here. Mrs. Stabile, I don't believe that she's here. Mr. and Mrs. Yob, any questions? No questions. Mr. Osenbach. You moved. Do you have any questions?
I got a comment.
Can you hear
I
me?
can't hear him.
You have to come forward.
You're store management, right?
I'm sorry?
You're store management guy, right?
Yeah.
Okay. Did you have any interactions with any of the people of the adjacent properties?
Not outside of hearing rooms. I think that we had some conversations between the various hearings in the town hall, and that was, part of the premise for having done our national hydrology study. So we heard some of what were presented to us as existing runoff issues.
Were the adjacent properties included in your studies, the ones that flood on Class Road?
So if you're referring to the, this preliminary stormwater analysis, it's not so much that they're included in the study, it's we're managing the runoff from the subject properties with the intent to not increase or in fact reduce what's leaving the site, which would of course have impact on the adjacent properties.
Do you know what the setback is for the retention pond on Class Road?
I can tell you, well, I can tell you two things. So, the first thing about what is currently depicted on the plan is the ponds are behind the buffers and behind the fences. And the fences are set up to be, let's see, basically for all of our front yard setbacks. The zoning front yard requirement is 35 feet, and we set them all at 75. So that would be from the street right of way to the fence, and then the ponds would be, you know, some distance behind the fence, so somewhere between 75 and say 100 feet.
Are you aware of Pennsylvania's 3 different zones?
I'm sorry?
Are you aware of Pennsylvania's 3 different infiltration zones for AMP?
Infiltration zones.
Yes.
I'm not
So
sure.
between 1 and 400 feet, you're supposed to take extra precaution for sediments and drainage due to the wells.
So the facilities that have been modeled are not infiltration facilities.
How do you plan to release the water that's in it?
It gets released on the surface through a control structure.
So that would release into adjacent properties then?
Well, if they're released at a dramatically reduced rate, is what would be required. So at every point of interest, we're not allowed to exceed. In most cases, we have to reduce to some degree the rate of runoff, and then of course control in a safe manner the actual conveyance of that runoff.
How would that runoff affect the adjacent properties, drainage fields, and septic and water wells?
Again, it would be it's required by both township ordinance and chapter 102 from PADP to reduce what's happening now.
In your experience, 10% significantly increases water runoff without you guys knowing or evaluating. How can you accurately depict your post-construction storm management?
You mean the slope? Yeah, so there's a few things. Certainly 10% is more than 5%, but it's also less than 15%. You know, we have a lot of projects that are on variable slopes. The idea is that all that water gets intercepted and conveyed to a facility where it then has to be stored and released in a controlled fashion. The biggest concern with the slopes is erosion, is the ability for water to channelize and create erosion. So, you know, one of the features that when fully engineering the project, again, much after a conditional use phase, would be looking at things like where can you break up flow as it goes down the hill, create some kind of level spreaders so that anything that does channelize has a chance to spread out and then spill over and go in a level fashion. All of it would still have to be collected in the basin, wherever the BMP is at the bottom of the hill, so to speak, before it can then be held and then slowly discharged. So there certainly are more considerations that would have to go in, that go into any project that has over 10%, over 15% slopes. Those also create, as we were talking about earlier, as it relates to the structural design and making sure that we want to try to mimic what's there now. We don't want to actually go in and try to grade and flatten everything out. And as you know, I've said many times, as we understand from preliminary geology, that the bedrock's going to be shallow, so we can't really assume that we can just make those kind of corrections. So it's going to have to be a ground cover and a stormwater control exercise. And again, the intent here with not just with the regulations, but with all the conversations that we've had and things we've heard about potential issues around the property, is that we want to reduce much further. And what we did in the study that we sent to Steve to take a look at was show that a lot of the reductions, whether it be the rate of runoff or the volume reductions are not just over the amount, they're pretty significant. Again, subject to final design, it's very preliminary, but we're going to demonstrate that we have the ability with the facilities as conceived preliminarily right now to really slow that stuff down. And that's really our intent, is to make sure that we are doing something to better any issues that were on surrounding properties, but for not, of course, being able to better anything directly, on those properties, just from what's going to be running off from the subject property.
So you and Mr. Clark referenced FAQ number 5. You guys just jumped right to it, but you guys can't meet number 4 on multiple occasions.
Yeah.
I noticed you didn't finish that paragraph. The very last sentence of that says, a comparison of pre versus post-construction must be evaluated. How can you accurately depict, if you don't know, the size of the panels, how much grading is going to be done? There's a lot of different variables that you guys aren't accounting for.
I'm not sure it's true. So pre versus post is the entire premise of the report, right? It's an analysis of the existing conditions and then analysis of the proposed conditions. Some of what you mentioned, grading, for instance, that to me is much more of a during construction condition. So post-construction stormwater management, it does flash completely from existing conditions in the post-construction. An entirely separate report, an entirely separate analysis is the erosion control report. And that's going to show what's going to be required during construction, whether they be sediment basins, sediment traps, combinations of silt sock, water bars and things like that that go up a slope like these to control water. And that's where I'd be looking at where are we doing grading and making sure that those areas are specifically addressed, because areas where they're not going to be grading can be seeded and be in pretty good shape during construction. So it's the during construction grading areas are certainly I would say the biggest emphasis that we have and potential for runoff during construction. But the stormwater report, as presented, again, is a post-construction report, which goes from current conditions and jumps all the way to end of construction conditions.
So my next question would be who maintains the retention ponds?
So the retention ponds are maintained by the O&M company, presumably, but the owner is responsible, but presumably they would have an O&M company. Also, I would say similar but different to the decommissioning bond, or the decommissioning plan, I should say, is that there would be an operations and maintenance agreement between the owner and the township. The premise for that being, if at any point the township or say someone looks across the street and says, hey, it looks like there's a problem there, the township can inspect it, instruct the owner in writing, hey, you guys got to clean this up. You have 5 days or whatever the township would do, after which time the township would have then rights to access the site and do whatever cleanup and backfill the owner for it. That's generally how an O&M agreement would work. I'm not sure exactly what the template is for the township. But certainly the project owner is responsible, but the physical work presumably would be a O&M company contract or something like that.
In the event of like a massive storm or something, say it overflows, who's responsible at that point? Is that an added cost to the township then?
So if you're saying like overflows and like, let's say causes damage across the street, honestly, where my head went there, that to me is something that cleanup and damage is probably going to be an insurance claim, but I'm going to maybe leave that to the lawyers to figure out. But certainly that would be something that the township under that O&M agreement would be, at least in part, looking at the owner and say, hey, you got to make sure that this kind of a failure doesn't happen. Because usually if a failure like that happens, it's not necessarily because there's something wrong fundamentally with the facility. It's usually one of two things. One is either just like a crazy storm, or the other one is that, say, an outlet structure is not being maintained, so it's clogged up, whatever it is, so that if the water doesn't have a chance to go out and the outlet controls the way it's designed, it's more likely to fill up and overflow. Now the overflows are designed to be a safe conveyance of those larger storms. But again, in the occasion or in the hypothetical that you're raising, to me that sounds like something that the township would have an opportunity to weigh in on through the O&M agreement, but would also, frankly, probably be an insurance claim.
So there should be systems in place for an overflow. Would that be monitored remotely as well?
No, typically an overflow is just like a spillway, but then with some kind of conveyance channel, an understanding of where that water is going to go. One of the things that happens when we go through permitting on these is we have to go through the Conservation District and the folks at DEP, and when it's not clear that the overflow from a site is going to get right into, say, a storm, like a traditional storm sewer or like a roadside drainage swale that can clearly convey what's coming out, they require what's called an all-site discharge analysis. So it's not just what's happening on the site, to maybe your first question. Then you actually do have to go look, where is this going? And provide analysis to the folks at DEP or the Conservation District, whoever's reviewing it. And if necessary, there may be a need for one of two things. One would be some kind of, say, armoring or stabilization. In really extreme scenarios, there could actually be a need to get an easement from a neighboring property owner. So the neighboring property owner would have to agree that, okay, I know that there's a scenario where water could be discharging through my property, and so now I'm going to require that certain mitigation measures be put into place and sign an agreement before you can proceed. Now that's a rare case, but it is something. It's a regulatory arrow that PADP has in their quiver. When those situations come up and they can't be resolved locally, they can step in and say, well, we need an agreement, otherwise we're not going to let that discharge go over the property.
And one last thing is the DEP requires 5 to 10 acres for a drainage field. All this water currently on class rate drains into 5 to 10 acres. And again, that can now be met in number 4, which is the sites shall not be located directly upslope to areas prone to flooding, particularly inhabited structures.
Yeah. And so I did review this particular section of DEP for a couple of reasons, just because I wanted to be understanding of what the intent was. And I think the intent, the high-level intent, is essentially FAQ5, right? It's like it's now we're definitely not just going to allow the site to be managed by ground cover. Can't just say, great, the grass is going to take care of it. There's a potential issue here, so now there really needs to be some engineering thought put into what's going to be put on the site to control stormwater. But I did get them to confirm it certainly isn't intended to outright restrict development, but that's why it's one of the conditions in FAQ4 that if all of them can't be met, not just a few, if all of them can't be met, then you have to jump to a rigorous engineering exercise, which is what we are starting to do and will absolutely have to do in spades to get permitted on the project. And that's frankly what we do on all the projects. FAQ4 was kind of a blunder. We don't have any municipalities that say, if you meet FAQ4, you don't have to meet our stormwater management ordinance. So it's actually kind of a joke around the industry. We have a lot of conservationists that say, show us where you meet all these things, but they don't read the last line that says, if you meet those things, then no detailed stormwater management analysis is required, because we have to do the detailed stormwater analysis anyway. So and I think it's something I understand that DEP is probably going to update, at least in my conversations, at some point, because they need to understand how the document actually functions in the real world, because it's not a regulatory document, it's just it's a guidance, so it creates some confusion for the Conservation District reviewers in particular of exactly how to enforce it.
Mrs. Balthaser, do you have questions?
I have a follow-up question.
Okay.
Unless you can speak loudly.
Yeah, I can speak loudly.
As long as she can get you.
Yes. Just as you just mentioned about the O&M and with the pond, like if grass grows or things go awry, that if O&M doesn't take care of it, then the township can take care of it and they can build a company. Is the township going to be going into this? And I would imagine like the pond is going to be in a fenced-in area. So is the township going to go in there and actually do something?
So I can let someone from the township answer that, but I could say, generally speaking, the O&M agreements for stormwater absolutely give township officials, let's just say a public works group, access rights. And that's either usually in the form of an easement that's delineated, or what's called a blanket easement that says they'll have access to the property and go anywhere. Now, normally they have to give some kind of notice, like 48 hours, send a letter to the owner, hey, do this, and if you don't, we're going to come in and do it. That kind of thing. You can't break and enter.
But I mean,
Right.
is the pond going to be behind this fenced area?
Yeah, so
Right, so
the intent would be that the facilities would be behind the security.
Right.
But just as, and I mentioned this before when, in Mr. Clark's questioning that emergency services, fire, police, don't all have access. So there would be certainly a mechanism, and I don't know, Public Works will also have direct access to, whether it's a code or a key or something to that effect, that they would be able to get in there and go do what they have to do, again, with proper notice, and should the owner's O&M contractor or whoever that is fail to respond. So there's a process for that. Certainly, one scenario that David mentioned was, some kind of presumably urgent thing, same thing overflows, that would presumably be handled like any other emergency where there would be a call, but there could be an opportunity for emergency services. They're going to try to through your fence. They got to get in there, right, to do whatever needs to be done on an emergency basis. But yes, the O&M agreement, and I don't know how it's drafted for this township exactly, is absolutely there to provide access rights and ability to go in and rectify an issue that an owner fails to correct.
And when you say owner, not Trail, not the land.
That's right, yeah. That's the owner, operator of the project. I can't speak to like the exact legalities of, presumably the underlying property owner isn't out scot-free of any, but they're presumably deferring during the life of the project, maintenance of the property, operation of the facility, of course, all those things, to the owner operator of the project. That makes sense?
Yep, that's all.
Thank you, Mrs. Valdez. Are there any questions from any members of the board? No. No questions from the board? There be direct?
Yeah, I just have a few questions.
Just like the ones that are too.
Done a good job. I'll be brief. So just to clarify, there were a lot of questions about the zoning narrative that was Board Exhibit 1 that was submitted with the zoning application.
Yes.
And that was submitted January 4th of this year, so coming up on a year. Correct. You did not prepare that zoning narrative.
That's correct.
However, there were questions asked about compliance with the zoning regulations, lot coverage, etc. And I believe that some of this is a recasting, not recasting, just reiterating your direct testimony. But for terms of determining compliance, the Casperi lot and the three Frederick parcels were all considered one, correct?
Initially, yes.
Okay. And the conditional use plans that are identified as Exhibit 3, those are different than the plans that were submitted with that January 4th application.
Right.
Correct? Okay. And that is a result of a determination that was made by the township's planning commission and engineer, correct?
I'm not sure exactly who made the determination, that's my understanding.
I'm sorry, please repeat your answer.
I'm not sure exactly who made that determination. I believe it was conveyed to us by the township engineer in the plan commission.
Okay. And I don't have it, I believe that was June 20th, correct?
Sure.
Sounds about right. Okay. And the decommissioning plan, that was made with respect to, go back. The conditional use and the determination was that the Frederick parcels and the Casperi parcels had to stand on their own, correct?
Yes.
Okay. So they're now treated as two different parcels that comply. They both comply with the zoning ordinance requirements.
Yes, and specifically, we were looking at the building coverage, making sure that the building coverage was compliant as a standalone for each lot, not as an overall similar to the project.
Okay. And the three Frederick parcels, I think you mentioned, just to reiterate, during land development, could be consolidated into one parcel.
Yeah, that's correct. If there is not a mechanism, as we have on other projects, to essentially ignore internal lot lines during a lease period, that the lots would be consolidated. And so there's a land development process.
Okay. And what is the land development process that occurs after the conditional use process?
That's correct.
And that's a very long process as well.
It is very typically, yes.
Okay. And it's at that time that more detailed design is done?
Yes.
Okay. And you had mentioned this stormwater design was preliminary.
Yes.
to get final approval, you're going to have to demonstrate to the township that you comply with the requirements of the zoning or the stormwater management ordinance.
In every letter.
The decommissioning plan that was, you testified to, that was Exhibit 11. Was this prepared in response to a letter from the township's engineer?
Yes.
Okay, and I believe if you look at Exhibit 16, do you have Exhibit 16 in front of you? It's a July 11th letter.
Yes.
Great Valley. This was the letter that you were responding to with respect to the decommissioning plan. There was a question asked about whether or not the zoning ordinance requires a decommissioning bond at the time of zoning approval. Do you recall those questions from Mr. Clark?
I do.
Okay. And if you look at paragraph 1 from Mr. Hoffman's letter, it says that this bond, this preliminary amount, which is preliminary, is not final, correct?
As far as I understand it.
That's okay. That a decommissioning bond be submitted in accordance with the zoning ordinance section at the time or in conjunction with preliminary plan approval. Is that correct?
Yeah, I mean, it says prior to or in conjunction with submission of the preliminary plan.
Okay. And that is after conditional use approval?
Yes.
Okay, so the township's own consultants are interpreting the ordinance in which the way you had described.
Close. I think what I had described was that the decommissioning plan really can't be finalized until the design's done, which would presumably be beyond the preliminary plan. I think he's suggesting that a preliminary amount needs to be determined and agreed upon. So yes, we may be saying the same thing. I understand that it won't become final. It can't possibly until the design is completely done. Otherwise, they'll take all subject to change.
Okay. This is more my edification. There was some questions about the topographic information that Mr. Cluck required. Is that information in these materials? So
the topography, existing topography of the site is depicted on the plan sheets starting with 2. So the sort of raw topographic surveys, I think, was essentially what was requested. But just for everyone's informational purposes, the sheets that are C2XX, whatever those are, they depict the existing topography as well. So they are part of the record.
Okay. So there's no, I mean, there's not going to be any additional information that can be gleaned from any other.
Just topography without any other stuff on it. Right.
I have no further questions.
Mr. Clark, are you going to have recross?
Sure.
Less than 5 minutes?
I'll try. The topographical survey is identified as a preliminary topographic survey prepared September 27, 2021. Is that the document relied upon for the topography in the documents that you claim have that information?
Well, I can jump to the end of the page from our last chat was that the date of the Frederick parcel being added on is not on there, but I believe that's the date for the disparity survey documents. And yes, whatever was provided on the survey has now become essentially what we call our base plan, which shows existing topography and existing features on the conditional use plan.
Was the preliminary topographic survey updated to include the Frederick lots?
It was.
I'd like that produced, please. It's not referenced in his plans. The conditional use plan says plan reference. It doesn't. I'm not going to answer this. Second question.
So I didn't even say for the record, the topography is shown on the entire project area, including the Frederick parcels. So it's just not, the date of the second survey is in reference, but the topography is depicted.
I stand by my request.
Julie got it.
You just testified that, and I'm not sure I got this correct, Mr. Gallagher said there are 2 properties involved here, Gaspari and Frederick. Is that how you analyze these plans?
We've talked about the fact that Frederick is comprised of 3 parcels, but it's two separate tracts that house arrays. Those were the essentially the denominator, the underlying areas for the coverage calculations. But it is eligible.
Well, you testified that they're in compliance with the zoning ordinance. Are you a legal expert? Were you qualified to give opinions on compliance with the zoning ordinance?
I believe in response to that question, stated that the compliance was primarily to check for building coverage, which is a calculation that was done in my office.
I'm not sure that was what the question was on redirect. There are 3 Frederick lots, is that correct?
Currently, as I understand it, yes.
And 2 of those lots do not meet the minimum 5-acre requirement in the zoning ordinance, is that correct?
Right.
That's all I have.
Thank you.
Mrs. Polonic, any recross? Mr. Balthaser? Mr. Hartman? No. Mr. Hopner is not present. Mrs. Stabile is not present. I believe Mr. and Mrs. Yauber are no longer present. Mr. Osenbach? No questions. Mrs. Balthaser? No questions. And this witness is now excused. Before you're excused, are there any questions from the board? No questions from the board. At this time, we will adjourn until December 5th, 2023 at 5:30 p.m. In this room, the large group instruction in the Hamburg Area High School.
Yeah, Ryan will be there. I only have a couple questions for him.
You'll be there on the 5th? Yeah.
Yeah, the 5th. I make the motion that we adjourn the meeting. Do I have a second? All in favor, say aye.
Thank you.
Go ahead.